welcome to this channel. Hope you all are doing well. In this episode, we'll discuss the burning issue of the Indian educational system, that is, anti-ragging laws in India. Origin. The concept of ragging can be traced back during the 7th century in Greece, where it was used as a game tool among the players to strengthen their mental ability and power and coalesce with the co-players and to uplift the spirit so that one can bear the rigorous process. Later, the thought has been traveled to the military. In the educational system, ragging has originated in Europe. It spread rapidly in the American continent during the mid-19th century among the students. The practice of ragging spread more intensely after the First and Second World War, when the military personnel started to join the colleges and the situation became worsened. The first death caused due to the ragging was in US, New York, in 1873. India being the hub of the education from the ancient times, but ragging came to the educational institution in India from the British after the First World War. Before 1960, the ragging in the educational institution used to take place in form of taunt, tease or similar nature, but violence was absent. India witnessed first death due to ragging in 1975. Gradually, ragging started to take the violent face in the Indian educational organization. As to the data of the Coalition to Uproot Ragging from Education, shown that till now in India ragging is present. Definition of ragging. As to the UGC regulation of 2009, ragging mean and include any disorderly conduct by word, spoken or written, or by an act which the effect of teasing, treating or handling with rudeness any other student indulging in rowdy or indisciplined activities which causes or is likely to cause annoyance, hardship or psychological harm, or to raise fear or apprehension thereof in a fresher or any other student, or asking the students to do an act or perform something which such student will not do in ordinary course and which has the effect of causing or generating a sense of shame or embarrassment so as to adversely affect the physique or psyche of a fresher or any other student. Laws that prohibit ragging. Some of the states in India, such as West Bengal, Andhra Pradesh, Tamil Nadu, Maharashtra, and others, had enacted their own laws to stop ragging. But in the center or the union level, there are some enacted laws that restrict ragging. 1. Indian Penal Code. In the Act, there are various provisions which addresses the punishment for ragging in various form and nature. The student who is victimized or the educational institution can register FIR in the closest police station against the student or the group of students who caused ragging. Some of the sections which address punishment against the various form and nature of ragging are Section 294, 323, 324, 325, 326, 340, 341, 342, 506 and others. 2. UGC regulation curbing the menace of ragging in higher educational institution, 2009. The UGC has framed the guidelines for banning the ragging in many ways, such as publishing in media, application form brochure, and asking for declaration in form of affidavit from the student and parents that they will not indulge themselves in the ragging, setting up of the anti-ragging committee and squad. The head of the educational institution can lodge the FIR with the nearest police station within 24 hours. Apart from the UGC, other educational bodies worked in the similar path, such as AICTE, MCI, DCI, and others. Punishment. Apart from the statutory laws, the educational institutions are armed with various powers for punishing the student indulged in ragging, such as 1. Suspension and cancellation of attending classes, scholarships, and from hostel. 2. Withholding the result. 3. Restriction from entering into the institution for 1 to 4 years. 4. Fine. Cases and judgments. In 2001, the Honorable Supreme Court in Vishwa Jagriti Mission through President versus Central Government through Cabinet Secretary and others directed the respondent, that is the Central Government, to give publicity of the suggested guideline of the court in terms of the order dated 4th May 2001. In 2009, University of Kerala versus Council Principal Colleges Kerala and others, Supreme Court recommended that every institution must have anti-ragging committee and anti-ragging squad, and the anti-ragging committee must consist of police officials, local media, NGO, parents, freshers and senior students, headed by the head of the institution. Anti-ragging squad must keep the strong vigil. The setup of the anti-ragging database and crisis hotline in the manner suggested by Dr. Rajendra Kachru. The draft regulation on curbing the menace of ragging as formulated by UGC should be adapted and to be adapted by the other regulatory bodies like AICTE, MCI, DCI, NCI and others. From the behavioral point, the willingness to rag another fellow student comes from the sense of authority. So long ragging continues with the intention of providing the newcomers a welcome note to enhance the mental strength and the feeling of oneness with other fellows was acceptable. But when violence added and ragging becomes a form of showing authoritativeness over others, started to take a different shape altogether as the victim goes through both physical and mental trauma and sometimes ending up with self-killing. Here the essence of legal bar becomes inevitable and the court and state authority can't stay mum and silent and comes into play by enacting and operating the anti-ragging laws to forbid the torture in name of ragging.